Dr. Lucy Gibbard, one of the medical legal consultants with Medical Protection. Today, I'm joined by my colleagues, Dr. Tim Cookson and Dr. Sam King, who are also medical legal consultants at MPS.
Hey, Lucy.
How you doing?
And today we are talking about what to expect when you receive an HDC complaint. Look, in New Zealand, we have a very unique medical legal environment where clinicians are almost never sued for personal injury in the courts. Our ACC legislation covers medical injury, and anyone harmed in the course of medical treatment can apply to ACC for cover and will be compensated through that mechanism. And I think we're going to talk about that in a later podcast. But this means that doctors in New Zealand aren't held to account through a court system. And we have another system, and the main body overseeing patient complaints and the standards of medical services in New Zealand is the Health and Disability Commission.
Getting complaints is never easy, and we all know that sinking feeling you get in the pit of your stomach when you receive a complaint, and certainly I've had that in the past. But we hope that giving you a bit of an idea about how the HDC works will help to clarify the system and remind you that MPS are here to help all our members through the process.
The HDC was set up by an Act of Parliament in 1994, and the first Health and Disability Commissioner was appointed, with the role of promoting and protecting the rights of health and disability services for consumers and facilitating the fair, simple, speedy and efficient resolution of complaints. Now, I know we may have something to say about how speedy the process is, but look, that's what they were set up to do.
That's right. It was set up after a recommendation by Judge Cartwright in her 1988 cervical cancer inquiry report, which many of you will remember, who highlighted the need for an independent complaint service and also a patient code of rights.
Yes, so the first commissioner drew up the Consumer Code of Rights, which still stands today, and the code sets out 10 rights. Now, look, I'm considering whether Sam and Tim should have to be able to name all 10, but I thought that might be a bit mean. But anyway,
Thank you, Lucy.
But yes,
You're right.
But the rights include the right to be treated with respect, to be free from discrimination or exploitation, the right to dignity and independence, and to services of an appropriate standard, the right to give informed consent, and the right to complain. So the HDC's role is to look into complaints and judge whether there has been a breach of any of these rights. So what are clinicians' rights?
Lucy, that's a question we quite often get asked by clinicians who've received a complaint through the HDC. Well, what are my rights in all of this? And somewhat depressingly, the code specifically states patients or consumers have rights, providers have responsibilities. And even more depressing in some respects is the statement that it is up to the provider to prove that they have complied with the code. So the onus is all on us. There is no code of clinicians' rights. It has not yet been produced, much as we would like to produce one. And so, in this situation, I think the code redresses the imbalance of power that used to exist between patients and clinicians, where patients had no power whatsoever. And in the aspect of complaints, it's actually the opposite way around. And it's the consumers who have the rights and the providers who have the responsibilities.
I think it's important to think that we do have the right to provide a response to any complaint. And so anytime you receive a complaint from the HDC, it's important to use that right. So take it seriously and get some help with it if you need to, because however you respond will largely determine, in many ways, the outcome.
And the Act requires the Commissioner to act fairly when conducting an investigation. So in situations where that doesn't seem to be happening, MPS will certainly protest very vigorously if it looks like the process is not being followed fairly.
Okay. So the HDC can receive complaints from patients, their family, sometimes concerned members of the public, and they also receive complaints from the coroner and the medical council occasionally. And they receive a lot of complaints. The last annual report, which is 2020-2021, noted that there had been a 23% increase in complaints over 5 years. 14% of which have been in the past year. And I think we've heard that this year, they've so far in the beginning of this year had a 25% increase in complaints again. So there's no doubt that the HDC are receiving more and more complaints. In the 2020-21 year, they received 2,721 complaints. And the advocacy service also deal with a similar number on top of that.
So, Lucy, how does the system work?
So the patient has several ways of complaining. They can email the HDC, they can phone the HDC, or they can fill in an online form. The complainant then gets the chance to tell their experience, and they're asked to name the health provider they're complaining about. So look, is it just doctors that get complaints to the HDC?
Well, no, we're not the only ones targeted, Lucy, fortunately. So any health provider, whether or not they're registered as a health professional, can be complained about, and the complaints can go through the HDC.
So they don't have to be a registered health provider. A massage therapist can be considered a
Absolutely,
a
and have been found in breach of the code for misdemeanours as well. Yep.
Okay, so moving on to the experience for the clinician, what then happens once the patient has complained to the HDC? The clinician will receive that dreaded email from the HDC with a letter that says that the HDC have received a complaint from so-and-so, and that they are gathering information to assess the complaint. They would normally also include a copy of the complaint for the clinician to review. Often the HDC letter will highlight a number of areas where they want specific information, but it's also really important to read the patient complaint carefully as well. And when you're writing your response, that you actually look at the issues that the HDC have raised, but you also look at any issues within the patient complaint and anything that's been brought up there. The HDC generally give the clinician 2 or 3 weeks to provide their response. So what do you do when you get an HDC complaint, Sam? What's the process for the clinician then?
Most clinicians get that terrible feeling in the pit of the stomach, and then they decide they're going to quit medicine and go into retail. That's usually the process people follow.
Iceland is also a suitable place to run off to.
The best thing to do when you get an HDC complaint, particularly if it's one that has terrified you, is to call your indemnifier. You know, most clinicians receive very few HDC complaints in their lifetime, and certainly not enough usually to become experts at responding. Whereas, you know, at Medical Protection, we deal with this every day. It's our bread and butter, if you like. So we know what to do. And because we're clinicians, we can look at the situations you're facing objectively and provide some really important information and walk with you every step of the way.
And I think that's important because often when a clinician receives that complaint, they kind of have visions of this is my career over. And putting things into perspective, looking at the vulnerability and the potential risks and reassuring clinicians that actually we think things are not going to be too bad is one of our most important roles as medico-legal consultants.
Mm. So what happens then, Sam?
Generally speaking, when one of our members contacts us, we will ask them to draft a response and send that in to us along with the clinical notes.
Yeah, it's one of the reasons we want good notes, isn't it? For
Absolutely.
When the HDC complaint, it really helps to have
it really
good notes,
does
doesn't
help.
it?
And the worst thing is that often when something goes wrong, we all go back into our notes, and most of us look a little bit horrified and go, oh my gosh, why didn't I write more? But anyway, I digress. So once they send their documentation to us, we allocate one of the medico-legal consultants or MLCs to assist, and we will go through the draft, read through the notes and make suggestions about how to respond. We always encourage our members to reflect on what has happened and think about what you could have done better, or what in hindsight you wish you had done differently. And I know that lots of our members find it very difficult to admit to error, particularly for the clinicians who perhaps have been through a university in a different or worked in a different jurisdiction where they have litigation. But it's really important when you approach an HDC complaint. If you've done something wrong, we always encourage you to front foot it and apologise and then say, well, this is what I've learned from that. Because with that kind of an attitude, you're going to get a more lenient decision from the HDC. I think for the doctors who, in the face of overwhelming evidence, refuse to admit that they've done anything wrong, it doesn't usually go as well for them.
One of the things that is natural for a clinician who receives a complaint is to feel quite defensive about it and to kind of launch immediately into that fight or flight, but the defense mode. And it can often be really useful to just try and stop, take a deep breath, and start to think about how the situation looked from the complainant's point of view. What was their experience? And sometimes if you can just shift your emphasis from the clinician's perspective to what it might have been like for the consumer in that particular situation, that can help to start shift in terms of how you approach the complaint and the kind of things you might say.
And it changes the tone of the response as well, doesn't it, when you've got that kind of approach? And obviously we've got to bear in mind that the complainant is going to get a copy of whatever you send to the HDC. So it really does make a difference if it's got a good reflective tone, and that shows that the clinician has actually really thought about it and maybe learnt something.
No, I think that's important.
So do we have lawyers involved at this stage?
For each of us, I think we all make a decision at the time we've reviewed the case as to whether or not a lawyer would be helpful. And lawyers aren't always helpful, I have to say, in a case. Simply because they have a different approach to doctors. They think very differently to clinicians, and sometimes you need that very legal view, but often you don't. And so we make that judgment call. And if we feel a lawyer is needed, then we have no hesitation to instruct one of our panel lawyers.
And certainly one of the things that I think about very carefully in that decision is how vulnerable is this doctor? And by vulnerable, I mean how likely is it that this will then lead on to investigation, which I know we'll be talking about soon, and the possibility of a breach finding against them. And certainly if I was a clinician in a situation where something had happened and that was going to be a likely outcome, I think I'd want all the available expertise to be assisting me. And so as a MLC, I'll always get a lawyer involved if I think that that's a potential that could go in that direction.
Yeah, and look, we're lucky that we've got lawyers who are very, very experienced in responding to the HDC and have a particular expertise in that area. So look, and that they work with the MLCs who are clinicians to try and make that response as good as it can be. So, it can be very helpful to have both if we think the member is vulnerable. So then what? What happens once that response has gone to the HDC? Then what happens?
It falls into a black hole usually, and we don't hear from them for a long time. No, it is a waiting game once you sent it off, and as many of you will understand, the HDC do take quite a long time to respond, and a lot of that's due to the increase in the number of cases that they have to deal with. And in the 2021 year, the statistics say that 64% of complaints are resolved within 3 months, 86% within 12 months. But that's a very long time. 12 months can feel like, and it is, a long time to wait when you've got this complaint sitting at the back of your mind. So usually these days what I tell members is, once you've got that complaint sent off, just put it out of your mind if you can and just carry on with work until something appears again by way of response from the HDC. Occasionally, we do write to the HDC and ask where things are at and if we can have an update. And unfortunately, sometimes the HDC can be a little slow in responding to emails as well, but it's worth doing rather than a member sitting there and just worrying excessively about what's happening in a case.
And obviously with the HDC, if the concerns raised are serious and they look at that response, often the next stage is that they may decide to proceed to an investigation. I think lots of clinicians don't really understand quite the difference between the information gathering letter and the investigation letter. So Tim, just what's that about? What's investigating? And what does it mean when you get a letter saying that they're investigating?
It means that it's serious and it has a lot of implications. So it's important to put it into perspective. So of the nearly 3,000 complaints, or even more now that the HDC is receiving per year, around 110 to 130 investigations are started. So it's only 1 in every 20 complaints that go to the HDC that will lead to an investigation. And almost always investigations involve some sort of clinical situation that has had a significant impact for the patient, for the consumer. So they very much revolve around that. And the decision to investigate is usually based on an expert who's looked at the information that's been provided and has made an initial decision about whether there may have been a breach, a departure from the standards that are expected. So the Commissioner then looks at this advice and decides, yep, no, there's something serious going on here, we're going to investigate. With that decision, the Commissioner will then notify the Medical Council, or if it's another professional, the regulatory body of that profession, so the Psychology Board if it's a psychologist. And that has some implications for the clinician as well. So if you're a doctor and this is notified to the Medical Council, it means you can no longer get a certificate of good standing. So if you're looking to work in Australia and you're being investigated, suddenly that could be affected by your inability to get a certificate of good standing. You may get a certificate of standing, but not of good standing, which is
I think they call
tricky.
it the certificate of professional status now.
Yeah. I'm reflecting my age. You're right. And the other implication is that this is going to take forever. There's going to be quite an exchange of letters, and usually the clinician will receive a letter and they'll be expected to respond within 2 to 3 weeks, and then there'll be a 6-month gap with absolutely nothing from the HDC, which is unfair to the clinician. The HDC also has responsibility to ensure a fair and speedy resolution of complaints, and this is not fair or speedy, this process. So we are upset about it. The Commission has acknowledged it. They're trying to do their best to improve things. I think they just have such a huge backlog at the moment that this is going to be a very difficult challenge for them to overcome that significant time lag. And we've had cases that have gone on for 4 or 5 years in the investigation process, which is a long time to live with that. So, yeah, if it's an investigation, it is serious.
And that time issue is for the patient as well, who's kind of put in a complaint as expecting some kind of a response to that, and the patient's waiting as well as the clinician, isn't it? So it's not a great situation, as you say, and they are trying to address it. Just tell me a bit more about experts. Who is the HDC expert that's making a decision about the care that I've provided or that one of my colleagues has provided?
Well, they need to be an expert in their field, so they need to be currently practicing in that field. And if it's a subspecialisation, there's an expectation that they should have significant knowledge of that subspecialisation. Often the colleges have lists of doctors who are happy to be experts. And if a doctor is asked to be an expert, there's a code that they have to comply with. And the start of all of their reports will be, I have read the code of experts for the HDC and will comply with that. They're expected to judge the situation not with hindsight, but as the case evolves, knowing what that clinician knew at that time and base their decisions on, they're expected to judge those decisions as a time basis rather than on a hindsight bias basis. And then they're expected to give a judgment as to what a body of their peers would regard as being the appropriate standard, and has the clinician met or failed to meet that standard. And then usually it's a code of mild, moderate or severe departure from expected standards.
It's hard not to have hindsight bias, because obviously that expert is going to know what the outcome was, and they clearly know there's been a complaint. So, and it's often very different from the perspective of the doctor who's actually been going through the case in real time. To have somebody else look back on it, it is hard to exclude that hindsight bias, isn't it?
It is, and I think in particular for the radiologists who receive complaints where a diagnosis has been missed on an image, and the radiology experts obviously know that something's been missed, otherwise they wouldn't be
asked to look at it.
And then they don't mimic the same conditions that all radiologists work under. And to be honest, I was a little bit shocked when I've spoken to some radiology members and they tell me just how little time they have to look at thousands of images. It's like you have to be extremely good to pick up, with pattern recognition, to pick up abnormalities. Whereas I think for the radiology experts, they generally have a lot of time.
Hours to look at one image.
That's exactly right.
If you look at, we actually asked the HDC, that was one of the cases that I was assisting with, how long the expert had taken to give their, in the time that it had taken them, compared to how long the initial clinician had got with that same image. And it was, hundreds of times different.
Mm. And not only that, but the readings generally aren't blind. So when you've got a radiologist expert, it's not a blind reading. They don't get 50 films and say, have a look at all these and report on them. They probably just get that case. And so they know they're looking for something abnormal.
Yeah. So look, what if the clinician who's been complained about disagrees with the expert? Because this does happen quite a lot, doesn't it? That actually the clinician either thinks the expert's got some points of fact wrong, or that maybe that their opinion is wrong, and that they disagree with what is standard care. So what happens then, Sam?
It's not uncommon, isn't it, for our members to disagree with parts of an expert's opinion. And so most of the time, we would encourage the member to respond to those criticisms or correct any factual errors. But very occasionally, and it doesn't happen very often, we believe that the opinion is really very poor and would be out of step with what their peers would consider to be appropriate care. And so we will provide our own expert opinion. So we will source an independent expert and obtain an opinion and send that to the HDC.
And in theory, the HDC is obliged to regard that opinion with an equal weight to the opinion that they've already got from their own expert. We haven't always seen the evidence of that, and we have a case with the previous commissioner who received an opinion from and I'm going to say so-called expert, because this expert had never done the surgical procedure that was the subject of the complaint, and had virtually retired from surgery at the time that he gave his opinion, which was of a severe departure. We ended up getting 3 expert opinions, all of whom were clinicians working in the field regularly, and all of whom felt that the surgery had been done appropriately. And the commissioner said he preferred his own expert to our 3 experts. So that required a judicial review. So I went to court, to the High Court, and the High Court judge said to the commissioner, no, you cannot take that view. You haven't given us a reason why you prefer your expert over the others. You need to go back and rethink this. And the commissioner fortunately took the hint and got another expert to look at it, who agreed absolutely with our experts, and we went from a provisional breach finding with threats to go to the Director of Proceedings to no breach and no adverse comment. So we try very hard to overcome biased and inaccurate expert reports.
Yeah, and sometimes it is. I had a case recently where the HDC expert hadn't been given a really important clinic letter that actually outlined the consent process in detail, and the clinician was being criticised about their lack of consent, and we had the opportunity to point out actually the expert clearly never got the really important piece of information that showed that consent. So, and often after we provided that further opinion, we do get a chance to look at a provisional opinion. So in an investigation, the clinician always should be seeing the provisional opinion before a final opinion is made. And that just kind of gives us another chance to look at it and actually correct any factual errors or actually address any criticisms.
Yeah, so that part of the process is fair, that there's the opportunity to challenge what the expert has said and what the commissioner is proposing on finding.
If you look at the overall figures from the HDC, it looks like most cases that go to investigation do result in a breach finding. In the 2021 year, the HDC closed 123 investigations, with 106 of those cases being found in breach of the code. And you've got to ask, do you think it's fair?
Are you suggesting that it's like the Russian penal code, where I think 95% of all people who are charged are found guilty? No, I think it's a lot better than the Russian penal code.
We're glad to hear that, Tim.
I think that two parts to the answer. One is that it's the selection of the cases that go to investigation. And remember, they've already had an expert opinion which considers that there has been at least a moderate departure before they're likely to commence an investigation. And so, yes, it's kind of pre-selected that there will be, there's likely to be a problem. And the second thing is that often there may be a breach finding, but we not infrequently see, particularly with a hospital case, that there'll be two clinicians involved. Neither of them will be breached, though one might get an adverse comment, but it's the hospital, the DHB as it was, that is breached because the organisation failed in its responsibilities to provide a safe environment for that patient. So it wasn't the individual clinician's fault, but it came down to the organisation. And many of those breach findings are against the hospitals or the DHBs rather than individual clinicians.
Well, it's interesting with regards to the number of investigations. Was it last year, was not very long ago, when the Ombudsman signalled that there ought to be an increase in the number of HDC investigations that are initiated. And so I think in the near future we will be seeing that there will be more investigations taking place.
Which is not going to help the speedy resolution of those investigations, because the poor old HDC will have to deal with a lot more investigations. And I don't know if you've read an investigation report on the website. If you really want to be scared with your bedtime reading, there's a list of decisions that are published, and they're often 80, 100, 150-page documents. So there's a lot of work goes into those investigations. They're not a once-over lightly.
No. So what is it? So if a clinician is found in breach rather than the DHB, what does that mean? Our members always ask us that. Often at the very beginning of the process, it's like, well, what happens if I am found to be in breach of the code?
I think one of the first things to say is that nobody gets struck off by the HDC. You won't lose your ticket, your APC, and you'll be able to keep working in general terms. So I just want to reassure the listeners about that. So the Commissioner can make a number of recommendations in their final report, including recommending that the provider should apologise to the complainant, so a formal apology is requested, and also work on how the clinician could improve their practice. They might ask the clinician to do audits and provide proof of an improved process. If the investigation raises concerns about a registered health practitioner's competence, the Commissioner might recommend to the practitioner's regulator that it to consider reviewing the practitioner's competence.
But in a more serious case, the Commissioner's got another option, and that's referring to a person called the Director of Proceedings. Now, they're an independent person, but within the office of the Commissioner. And the Director of Proceedings is a lawyer who makes a decision about whether the breach has reached a level that requires discipline or referral to a tribunal to look at discipline. And if that's the case, action may be taken against the provider. So it'll either be the Health Practitioners Disciplinary Tribunal or occasionally the Human Rights Review Tribunal. So in the last year reported on the HDC website, 25 cases were referred to the Director of Proceedings, and only in about half of those cases did it end up going to a tribunal of some sort. And of those, around about half will be because of a really serious medical error that occurred, and the belief is that needs to be explored further for discipline. but many of them are behavioural things. So it's inappropriate behaviour with a patient, and that is very likely to end up with a referral to the tribunal.
Okay, so I think we're actually going to talk about the Health Practitioners Disciplinary Tribunal, it's a mouthful, in another podcast. So look, we won't go on further there. But do you guys think there's anything else useful we need to talk to our listeners about regarding the HDC process?
Well, clinicians' confidentiality is one of the things that we worry about. Are our names going to be published? It's exceedingly rare for the HDC to publish the name of an individual clinician. They will often publish the name of an organisation, so it'll be a hospital or a major provider. For example, a rest home name may be published, but it's exceedingly rare for an individual clinician to have their name published. And so in the reports that come out, it'll be Dr. A, Dr. B, Dr. C in the reports, but not their names.
I think we've already talked about it a little bit earlier around the time it takes for complaints to be processed, and the fact that the clinicians, are given very short timeframes to respond. Certainly, the HDC are usually okay about providing extensions if you need the time, and it's certainly worthwhile asking for that, because what's most important is that you provide an appropriate and robust response rather than a quick response. But certainly the timeframes can be very stressful. But just be aware that it's not because the HDC want to drag their feet. I think it is a resourcing issue.
And there's another aspect that we haven't talked about is that the Commissioner is obliged to take into consideration all of the circumstances surrounding a case. And so particularly at the moment where all health providers are just absolutely stretched and it's incredibly difficult to actually provide a good service because of the resource limitations, the Commissioner is required to take that into account when considering a case. That doesn't mean to say that it's going to get you off if you're working under difficult situations, but at least we know that has to be part of the Commissioner's thinking. And if there's no evidence in a situation where it clearly was a factor that the Commissioner's actually thought of that and talked about it, then again, that's something we'll challenge with the Commissioner.
Mm. And look, I do think the HDC process is reasonably fair. And when we come across instances where we don't think it's been fair, MPS are pretty good at challenging it. But when you look at the court systems in other countries, I think at least the HDC really does give consumers a chance to be heard and to have their complaints reviewed by an independent body. And it also gives the providers a chance to give their side of the picture. So yes, the process can be long and definitely stressful, and a lot of clinicians find the process very distressing. But I actually think most of us are probably more worried about that process than we need to be, because obviously a breach finding is rare, disciplinary proceedings are even rarer. So actually, as a process, it's one we probably worry about more than we need to, and that actually we can probably look at the HDC as a necessary organisation in order to be able to review complaints and provide independent advice. So, we hope this has given you a bit more insight as to how the HDC process works for providers. But if you have any questions about specific cases, our members are welcome to give us a call on our advice line, which is on 0800 22 55677. Or you can email us on advice@medicalprotection.org. Alternatively, if you want to contact us about the podcast, or if you've got suggestions about future podcasts or topics that you'd like to hear us talk about, please email us on podcastsnz@medicalprotection.org. So thank you, Tim and Sam, for sharing your knowledge and experience with us today, and thank you for listening to our podcast. I hope it's been helpful. We look forward to catching up with you in our next podcast. If you like Medical Protection podcasts, please subscribe and leave a review. Thanks, guys.
Cheers,
Thanks,
Lucy.
Lucy.